Welcome to our 5 St Andrews Hill discussion today in conjunction with Black Cultural Archives, where we'll be discussing the Mangrove Nine Trial. My name is Kevin Dent, King's Counsel, and I'm joined today by Chris May. We are both barristers at 5 St Andrews Hill, and we both specialise in serious criminal cases. And as part of our series with Black Cultural Archives, we are going to be looking back as lawyers at an important pivotal moment in Black legal history in this country, a moment which still informs our world and legal system today. And it has been fascinating and valuable for myself and Chris as senior lawyers to look back and learn about this key moment in both legal history and also the fight against discrimination. So Chris, over to you. I'm going to start with you. What is meant by the Mangrove Nine Trial?
Thanks, Kevin. Well, the trial of the Mangrove Nine, as they became known, lasted in the end for 55 days over 12 weeks at the Old Bailey in London in 1971. There were 9 defendants in all who were prosecuted for serious offences, including inciting a riot and a fray and other lesser offences. And the case arose out of a march which was organised in protest against the way the police were felt to have been acting from racist motives, particularly in raiding a restaurant which was very popular within the Black community in Notting Hill called the Mangrove. The trial judge who was chosen to preside over the case at the Old Bailey was His Honour Judge Edward Clarke, who was a well-known establishment figure at the time and renowned for his brusque attitude in court. The trial had a huge impact on the public at the time and a more lasting significance in British legal history and in the recognition of institutional racism in the UK.
Okay, and Chris, next thing is, can you introduce us to the actual Mangrove Restaurant itself?
Well, the Mangrove Restaurant opened in All Saints Road in Notting Hill in March 1968, and it rapidly became a centre of Black community culture, and also it was perhaps a limb of the counterculture at the time in the late 60s. It's been referred to as a resting place in Babylon. But whilst on the one hand it developed into an important meeting place for Black radicals, the Mangrove also became the heart of the Notting Hill Black community. It was the successor to a cafe called El Rio in Westbourne Park Road, which had also been run by the same Black proprietor. El Rio had been called the first Black restaurant in the Grove, and decorated with African art and pictures of hip musicians. It had been visited by many famous writers, artists, musicians, and actors, including people like Jimi Hendrix, Marvin Gaye, Diana Ross. And as well as being such an important meeting place within the Black community, the Mangrove was frequented by all sorts of people at the time, broadcasters, journalists, and writers. And importantly, people of all different sorts of backgrounds and ethnicities. And the Mangrove also had a license to remain open later than the usual closing hours at the time, which became important later on when the police began to take action against it. So Kevin, perhaps you could talk us through some of the key players involved in the Mangrove case.
Yes, well, just concentrating on 2 of the key players. Firstly, there's Frank Critchlow himself, the owner of the Mangrove Restaurant, originally from Port of Spain in Trinidad, and he was go on to become a central figure in the Notting Hill Carnival. Arrived in England in June of 1953 on the SS Columbia, and so part of the Windrush generation. And he worked initially for British Rail, and then went on to form a band called the Starlight Four. And this is a band had quite a lot of success. They've been on TV and radio a number of times. And by 1959, Mr. Critchlow had earned enough money from his band to open the El Rio Cafe in Notting Hill. And as you already mentioned, that became a fashionable meeting place for the likes of people like Christine Keeler and John Profumo. And it was also considered to be a safe place for Black people to meet. Then in 1968, he opened the Mangrove Restaurant, as we've already mentioned, and that too has had a number of celebrity visitors. But as you have indicated, came under unwanted police attention. So that's Frank Critchlow, one of the key players. And perhaps the other key player was Darcus Howe. And he was born in 1943, originally from Trinidad, had a very prestigious education in Trinidad, went to a very good college, and was also a top cricketer there. He arrived in England as a teenager in 1961, settled in London, and first of all studied law. But after 2 years at the Middle Temple, he left. He became more involved with journalism and radical causes. Later on, of course, would go on to become a pioneering broadcaster in the 1980s, involved in a number of groundbreaking television programs, including Devil's Advocate, programs that went on to transform people's attitudes towards race and class. So they're two of the key players. And Chris, before we get on to the events that led up to the arrests and the trial, what was the police's attitude to the restaurant? I'm thinking about police raids.
Well, there's a strong argument, looking back at it, that the local police failed to draw a distinction between, on the one hand, Black radicalism, and on the other, criminal behavior, and that they merged the two together. And the police began a series of raids, which were based on warrants for suspected drug dealing at the Mangrove. An irony of all of that is that Frank Critchlow, the proprietor, had a strong personal stance against drugs. And so this series of raids took place starting in 1969 and including, astonishingly, 10 different raids in a period of 6 weeks in 1970. And these raids were increasingly heavy-handed. And it's important that no drugs were ever found by the police in any of those raids. But then the police used the fact of the raids, supposedly as evidence, to back up an application to the Magistrates Court to rescind the Mangrove's late-night license. And in what might be regarded as an extraordinary decision, the court rejected the police evidence, but granted the application to revoke the late-night license. So the application really was circular, because although the police didn't find any drugs, they used the fact of raids to try and find drugs to object to the license, and that application succeeded. And then in May of 1970, Frank Critchlow was arrested after a raid for using the premises late without a license. And he was prosecuted in the Magistrates Court. But the evidence was based on this after-hours raid, a late-night raid on the Mangrove, when all the police found was 3 people eating sweet corn and 6 more drinking tea, and the doors of the restaurant were locked. And the magistrate on that occasion found against Frank Critchlow, and he was convicted and he was fined. But a highly unusual feature of that case in the Magistrates Court, which centered really on a fairly minor breach of licensing laws, which was being alleged, was that over 20 police officers attended specifically for the case and were present in and around the court building, which perhaps shows the sort of attitude which the police had developed about Frank Critchlow and the Mangrove, and shows the sensitivity which was building up about the Mangrove and what it was beginning to stand for in the eyes of the police. And so more police raids followed.
So, Chris, then what happened on the actual march itself on the 9th of August 1970, and how did it lead to the arrests?
Well, there was a real contrast between how the march started off and how it finished. So the march was organized, as you say, to take place on the 9th of August, and the purpose was to protest about the police treatment of the Mangrove. The authorities were informed in advance of the march and its purpose, which was, to quote, to protest against constant police harassment and an end to the persecution of the Mangrove Restaurant that serves the Black community. So on a fine summer's day, about 150 marchers assembled in early afternoon. Darcus Howe addressed the crowd before the march moved off, as also did Althea Jones Lecointe, who was a prominent Black activist, a member of the Black Panthers who was present. And the mood was initially good-natured, although clearly a protest. But what was significant in a way to start off with was that although there were about 150 marchers, there was from the start a police escort of about 200 police officers. So substantially more police officers than marchers right from the beginning. And there were some placards held by some of the marchers, amongst which there were slogans referring to the police as pigs, which was a frequently used comment or word at the time to describe the police. Now, one protester even carried a pig's head. There were some members of the British Black Panthers present, which was the UK branch of the American Black Panthers, who were championing Black rights in America. And so the march moved off first to Nottingdale police station. And near the police station, Darcus Howe again addressed the crowd. And by this time, there were significantly more police than marchers, because more and more reinforcements were being called up. And so later on, when it came to the trial, a police inspector, Aldred, admitted in cross-examination that there had been 500 police officers available that afternoon. And yet police records actually show that in fact there were 705 police of various ranks deployed, as well as an undisclosed number of special branch and other plainclothes police officers. Well, the crowd began chanting. One of the chants was, "We want Puller," referring to PC Frank Pulley, a local police officer who'd become notorious in the community for his aggressive approach towards Black people. Some police officers, some police witnesses said at the trial later on that they thought that the chant was a prelude to violence. But in fact, transcripts of the police radio traffic show that the reinforcements had been called for before the chanting even began. So the march moved off towards Harrow Road police station, turning up Ladbroke Grove. And it's clear that the police were becoming, at the very least, increasingly nervous. When the march reached Portnall Road, the police lines deployed there were 5 deep in front of it. And shortly thereafter, the previously peaceful demonstration turned into a violent confrontation. It became known colloquially afterwards as the Battle of Portnall Road. The cause of the conflict became one of the central issues at the trial. The police later gave an explanation that the march was stopped ostensibly to allow traffic to move. And it's possible that the police commanders panicked. There were claims however, by the police that the marchers had deliberately used the march to ambush the police, which doesn't really fit with the fact that the marchers encountered these ranks of police officers in front of them. On the other hand, Darcus Howe later described what happened as being pure police brutality. But within a short time of the police stopping the march, violence erupted. For about 15 minutes or so, there was widespread fighting between the police, armed with batons, and the marchers. And some of the protesters responded by throwing bricks and stones and bottles. And a lot of the marchers fled, including Darcus Howe, who fled back to the Mangrove Restaurant. Many of the marchers were arrested at the scene, but that evening the police arrested others who were seen to be the ringleaders, including Darcus Howe. Darcus Howe, and others later accused the police of beating them using really unnecessary levels of violence against them when they were arrested. And so some 19 people were arrested in all. So that's the march. So Kevin, perhaps you could tell us about what happened afterwards when they were those who'd been arrested were prosecuted at the Magistrates Court, and what the prosecution stance was after the Magistrates Court hearing.
Yes, well, what happened in the Magistrates Court became quite important to what then happened later in the proceedings, because the defendants were originally charged with affray, which is far from the most serious public order offence. So initially charged with that, but then a few weeks later, the police added charges of riot and incitement to riot, so very much more serious charges. But these new charges, however, were challenged at the Magistrates Court proceedings. And back in those days, you could challenge charges at the Magistrates Court and seek to have them dismissed or discharged if the evidence relating to them was weak or non-existent. So there was a 5-day hearing at the Marylebone Magistrates Court, and the judge at those proceedings, David Watcher, caused a sensation at the time because he ruled that there was no evidence to support the charges of riot or incitement, which was a huge blow to the prosecution. And there were initially big celebrations about this result from the defendants. But it's clear that the prosecution had not given up, because they then took what was the highly unusual step of applying for what was known as a voluntary bill of indictment, in effect overruling the decision of the magistrate and pressing on for a trial on the charges of riot and incitement. So those charges were brought back by this procedure. So Chris, at the trial, who was representing who, and what happened at the preliminary applications in the Crown Court?
Well, of course, there were 9 defendants, and each of them was entitled to separate legal representation by a barrister and solicitor at the trial. But Darcus Howe in particular, and Althea Jones-LePoint as well, were determined to use the trial to voice their complaints against the behaviour of the police and to try to use it as a platform for airing their wider and more deep-seated grievances. In fact, Darcus Howe had been advised by a solicitor in advance of the case to plead guilty. Not only did he reject this advice, but he decided to represent himself in court, as also did Althea Jones-LePoint. They realized that by doing so, they would be less restricted than legal professionals in what they felt able to say in court. And the fact that they were representing themselves evidence also enhanced the level of publicity that the trial received. Barbara Bees, who was another defendant who was Darcus Howe's partner, was represented by a barrister called Ian MacDonald, who was then a relatively junior barrister with limited criminal experience, although he later went on to become an eminent and distinguished Queen's Counsel, particularly in the field of immigration law. But he was already an activist lawyer. And so Ian MacDonald was trusted by Darcus Howe, and so he was able at the trial to perform the crucial role of liaising and mediating between, on the one hand, Darcus Howe and Althea Jones-LeCointe, who were representing themselves, and the lawyers who were representing the other defendants, to try to put forward a united strategy at the trial. So Ian MacDonald later described the approach of Darcus Howe and Althea Jones-LeCointe in this way. To quote him, he said, "There were fundamental political issues that they were determined would be dealt with in the trial, including the level of quite blatant racism at the time."
And so, Chris, can you also say something about the applications at the start of the trial, and also the applications in relation to the jury?
Well, the trial began with a defense application to have the charge of incitement to riot removed from the indictment because it had been dismissed by the magistrate at the committal proceedings, so the most serious charges. And this provided the first opportunity for Darcus Howe to address the court himself, representing himself. And one of the things he said, again to quote, was this: "Many ordinary people would wonder how I could be tried twice for the same offense, having had the charge thrown out once before. As a common man, I feel this is a breach of natural justice." So quite a powerful argument. But Judge Clark ruled that he had no power to dismiss the reinstated charges. And then the next series of applications concerned the jury and the makeup of the jury. And Ian MacDonald took the lead in this. He was representing Darcus Howe's girlfriend, Barbara Bees. And he made an application for the case to be heard by an all-black jury, as all the defendants were black. The application took the best part of 2 days and tried the patience of the trial judge, who clearly was not minded to rule in favor of this. But Ian MacDonald quoted a lot of old cases by way of precedent, including cases that allowed Welsh people to be tried by a Welsh jury, Italian merchants by those who spoke Italian. And he also referred to the old previously established practice of a jury being selected from the neighborhood of the accused, which in this case, of course, would have resulted in a lot of jurors from the Notting Hill area and would likely have led to there being many more black members of the jury. But all of these applications fell on deaf ears and were refused. But although the applications themselves, the various applications, were unsuccessful, Darcus Howe felt that the making of the applications themselves were themselves a minor victory, because it caught the imagination. And so after that, the public gallery was packed. The press picked up the story, and from then on, the trial was extensively reported. And they followed the process of what's called impaneling the jurors, so choosing a jury. And at that time, the defense still had the right to challenge up to 7 jurors for each defendant. And the defense could still find out a bit about individual jurors, including their occupations. And so, as a matter of collective strategy for the case, the defense each used their full number of challenges to try to obtain the most favorable jury they could. And they used up all 63 challenges that they had, ending up with a jury that had 2 black jurors and 2 women, as well as 8 white men. There were other applications made by Darcus Howe and Althea Jones-LeCointe to have assistance from somebody to represent them, known as Mackenzie Friends, after a case called Mackenzie. But all of those applications were rejected, even though, as a matter of law, they could have been allowed. So, Kevin, moving on to the trial itself, how did the police evidence go, particularly the police observation evidence?
Well, the short answer, Chris, is that the evidence went very badly for the police and the prosecution. It was the Crown's case that the defendants had deliberately conspired to provoke their supporters into violence. But contradictions in the prosecution case began to emerge almost immediately. The first major witness to be called was Superintendent Joseph Donnelly, who said he was in charge of the police operation that day and had authorized the use of an unidentifiable observation van containing PC Pulley. And you already mentioned a bit earlier on that PC Pulley was a local officer who had a very bad reputation for racial provocation and violence. And when the superintendent was challenged as to why such a divisive figure had been deployed to police the march, Donnelly said that he had told Pulley not to interfere or get involved in any trouble. Superintendent also said that there were no plainclothes police officers present, but the next witness contradicted that and said actually there were 12 plainclothes police present. And during the evidence, Darcus Howe really got into his stride in terms of cross-examining officers, using in a way his advantage that he was representing himself, and so therefore a bit freer in terms of the kind of questions that he could ask and how he could ask them. And he used that in order to ask sort of deep and probing questions of the police officers. The notorious officer Pulley himself was called, and he gave evidence that Darcus Howe had been standing on a wall and shouting "Death to the white pigs." But Darcus Howe was able to establish in cross-examination that this was actually impossible for Pulley to see from where he claimed to be standing. So with these and many other contradictions, the prosecution case continued to unravel. And there were 4 other officers who were key eyewitnesses. They claimed to have seen the defendants goading the crowd from their position in a police van. But it was established that the tiny slit in the window available to view these events was too narrow for this to be true. And it actually, the jury at some point went and had a look at the police van, and that was seen to be true. Civilian witnesses were called to try and bolster the prosecution case, but they actually seemed to have the opposite effect, and suggesting that actually the violence didn't seem to be pre-planned at all. So that's how the evidence went. But Chris, tell us a bit about the verdicts and also the judge's comments at the end of the trial.
Well, all 9 defendants were found not guilty on the most serious charges that they faced of incitement to riot and affray. Darcus Howe, Frank Critchlow, Barbara Bees, and 2 of the other defendants were found not guilty on all of the counts that they faced. And so in all the 32 offences alleged against various defendants, there were only 9 convictions, all of which were on the more minor charges. And when it came to sentence, the judge, Edward Clarke, in spite of having a ferocious reputation as a sentencer, suspended the sentences of the 4 defendants who were found guilty of specific minor assaults. And so the result was that for all of the concerted efforts to prosecute the 9 defendants, the Mangrove Nine, none of the defendants ended up having to serve a prison term at all. But of great significance, however, were some of the words used by Judge Clarke at the end of the case, when he said that the trial had been, again, to quote him, a very unpleasant experience for everyone concerned, and that it had regrettably shown evidence of racial hatred on both sides. So, Kevin, looking back at the trial, what would you say was the significance of it, and what can we learn from it?
Well, the trial was highly significant in being the first, perhaps the first judicial acknowledgement of racial prejudice within the Metropolitan Police. And it also went on to inspire a number of other civil rights activists, black rights activists seeking to take on the legal establishment. And Ian MacDonald, the junior lawyer involved in the trial, he said about it, that he said that the Mangrove Nine Trial was a watershed because we learned through experience how to confront the power of the court, because the defendants refused to play the role of victim and to rely on the so-called expertise of the lawyer. Once you recognize the defendant as a self-assertive human being, everything in the court has to change. The power and role of lawyers, the advocacy and the case preparation. What all radical lawyers have to decide is whether they want to retain their slice of the traditional lawyer's cake or to participate in a bold new experience. And so certainly the trial is seen as being part of a bold new experience. And of course, the case has retained its significance over the years, as can be seen from numerous television programs about it, and even films. Of course, lately, the film by British director Stephen McQueen, Mangrove, which came out in 2020. So it's still seen, I think, as an important case and a landmark case, and pivotal in the development of community resistance to discriminatory policing. So there's more to be said about it, but those are the things that came to me. Chris, how about you? I'll put the same question back to you.
Well, looking at it from a purely legal perspective, in terms of what happens in criminal trials, one of the consequences was that there were some important changes made to the way juries can be, or potential jurors can be challenged because of the strategy that was used by the defense. And so to try and stop that, one of the things that was done, because similar approaches were used in some of the terrorist trials, was that there was a direction that jurors could no longer be challenged on the grounds of race, religion, political beliefs, or occupation in 1973. And that was then followed by a direction by the Lord Chancellor to remove the occupations of jurors from the available list of jurors, to stop that being, to quote, abused by the defense in cases with political overtones. And then moving on from what happened at the time of the trial, Frank Critchlow, of course, the proprietor of the Mangrove, bearing in mind that this all came about because of the police raids, the police harassment of the Mangrove, that the harassment of Frank Critchlow continued. He became an increasingly well-known community figure, as Kevin's already mentioned, involved in organizing the Notting Hill Carnival as it grew. But he was prosecuted twice more for alleged offences arising out of police raids. And each time he was found not guilty. And it wasn't until the end of the 1980s that eventually he received substantial damages, £50,000 from the Metropolitan Police, but never got an apology. And then Darcus Howe, of course, as Kevin's already mentioned, became a very, very high-profile broadcaster and commentator and activist for social justice, and particularly for social justice within the Black community. So the case challenged perceptions of an impartial criminal justice system. And apart from all the legal changes, perhaps a lasting significance is that a majority white jury had rejected the main allegations by the police when the defense was conducted on the basis that the police were lying in their evidence and should not be believed.
Indeed, and it's important for us as lawyers to learn about these moments and to appreciate just how difficult and tough things were, even a short time ago, and highlighting the huge problems of discrimination and discriminatory policing at that time. And of course, even though thankfully significant progress has been made, we all need to look back at the past and make sure that these important lessons are never lost. So Chris, unless anything else you wanted to add? I mean, we could talk about this for, I think, quite a long time.
We could, but no, thank you, Kevin. It's, as you said at the start, it's been very interesting having the opportunity to go back and look in depth at what happened.
It is. And so, Chris, thank you. And thanks to people for viewing this. Please do check out and look at the other videos in our series, 5 St Andrews Hill, and podcast in these series. And yeah, thank you for watching.